हाय दोस्तों, ब्रास ग्रुप के चैनल में आप सभी का स्वागत है। ब्रास ग्रुप आपके लिए लाया एक नया लेसन। आशा करता हूँ आप लोगों को पसंद आएगा। धन्यवाद।
There are few questions which come up and very fascinating questions, as fascinating as what Manu asked the other day, and I really thank all of you for raising that question on alien enemy, because I spent at least a few hours on it, and I still believe that I need more time to go through the literature covering alien enemy, and we'll be spending some time today to understand the concept of alien enemy with three different cases. Just to give a brief background, and some of you might be thinking that why did I start the discussion with alien enemy? There is a precise, just give me 1 minute, let me close all this international trade law thing. Yeah. So what we have been doing in this, in our private international law lectures is that we have picked up different concepts right from the first lecture. We saw how foreign element is an important criteria. What is the definition of private international law? Similarly, what are the justifications, basis, rationale behind private international law? We also got into this exercise. Of, say, identifying proper names for this subject, and saw that how private international law is a term which is often invoked in relation to this body of law. And in addition to that, we also have conflict of laws. There are criticisms and acceptance in relation to both the names. We also saw how unification efforts are made in relation to private international law rules. We also saw the character of private international law in terms of how it tries to tamper with the idea of space and time. Subsequently, we were trying to look at different stages of private international law dispute. In so doing, we started our discussion with jurisdiction. I'm so sorry. So I'm still stuck with international trade law class. So whenever you come across this term international, just remind me that, you know what I mean, you are getting too loose with your vocabulary. All right. And when we were talking about the concept of jurisdiction, we tried to reflect on the fundamental attributes of jurisdiction, and we saw that what is jurisdiction, what are the core concepts of jurisdiction, and how the concept of jurisdiction differs in relation to purely local matters and a transnational matter. We also saw how the US restatement of the conflict of laws tried to say that there must be some link in order for jurisdiction to be established. And we were trying to reflect on all those aspects one by one, which were listed as part of US restatement of law, of the conflict of laws. Subsequently, what we did in the last lecture was to talk about this question that can aliens sue? And in that regard, we refer to the laws in India, and we saw that Section 83 tries to answer this question, can aliens sue? And in terms of Section 83 answering this question of can aliens sue, what we also saw was that aliens are divided into multiple categories. So aliens are first divided into alien enemies, that's one. Second category which aliens are divided into are alien friends. Now, alien enemies are further divided into two more categories. One category is those alien enemies which are residing in India with the permission of the central government, and those alien enemies which are residing in India without the permission of the central government. Now, there's a third category of alien enemy as well, that those alien enemies which are residing in a foreign country. So maybe not residing in the country with which India is having a war. And then we also read the explanation to Section 83. And the explanation to Section 83 read as that every person, now we need to make a distinction between the phrases which have been used in Section 83, that every person residing in a foreign country with which government of India is at war with, and so going by the simple reading of this text, it is a disjunctive idea and carrying business in that country. Now, the word which is used in the explanation when it says every person is not alien enemy, unlike the main part of of Section 83. And when that person is carrying on business in the country without any license from the central government, then for the purposes of Section 83, that person will also be considered as alien enemy. Now, the question which Manu asked, and it was such a justified question, that what would happen, and a number of situations were posed, in fact, not just the specific situation which Manu identified, but a number of situations where, say, a person is a citizen of, say, Sri Lanka, but then goes on to live in Bangladesh. Or, for example, a person is a citizen of say, Pakistan, and India is having a war with Pakistan, and that person does business in 5 or 6 different countries. Or if a person is residing in 2 or 3 different countries, then how would the determination of alien enemy really work? This is the question which is troubling us for now. Now, what I did was to find some literature on alien enemy. And let me tell you, at least when it comes to India, I could not find one complete text, or at least a partially comprehensive text dealing with alien enemy. I looked at least one of the CPC books which I had access to, and there is not more than a paragraph on alien enemy. Similarly, I tried looking at some of the articles published in good journals, and I could not find anything substantive on alien enemy and how to determine alien enemy. And it was at this point of time that I realized that okay, just give me 1 minute. Okay, sorry. So it was at this point of time that I realized that maybe we'll have to go to the specific cases which has dealt with the idea of alien enemy. Now, when I tried to get into specific cases, and Jagminder pointed out Daimler Company, of course that's a case, but maybe there are other cases as well which are far more accurate in terms of dealing with law relating to alien enemy. What I will do in the discussion today is to highlight some of these cases and the points mentioned in these cases. So I tried to read at least 3 cases on the question of alien enemies, and all these 3 cases list down various rules relating to the determination of alien enemy and how the business of alien enemy is to be identified and understood. So we will try to understand the idea of alien enemy, at least in the first part of the lecture, with the help of these 3 cases. The first case is Firoza Begum and others versus Diwan Daulat Rai Kapoor and others. Before I move forward, let me tell you that all these cases are not decided by all these cases are not private international or disputes as such. These are general cases as well, but where the concept of alien enemies have been talked about. Now let's talk about all these cases one by one. When we talk about Firoza Begum and others versus Diwan Daulat Rai Kapoor and others, to put the facts very briefly, because the facts are not relevant for our discussion in terms of how private international law plays, this is a property dispute between 2 persons. There's a person in Daryaganj, in one of Daryaganj area in New Delhi, and he had some property going by the facts of the case, and in 1944 he leased this property to another person, and it was initially leased for 6 months, and then it was subsequently extended. The period is not fixated there. Now, in 1947, the person who leased the property to the other person, he left for Pakistan when partition took place, and subsequently the property was transferred in someone else's name by that person. And now, when these persons in whose name the property was transferred by the original owner, they came to take possession of the property, it was told to them that the persons who are actually in possession of the property, they are the actual owners, and the person who has moved to Pakistan in 1947, he is not the actual owner. Now this is how the facts are placed. Now the matter was before the court, the Delhi High Court, and one of the arguments which was made before the court was that these are alien enemies, especially because of the war in 1965, and since the matter was being heard during 1971-72 when India was having war with Pakistan. These are alien enemies, and and therefore the suit is not maintainable. It is in this regard that court made certain observations with regard to alien enemies. So what I'm going to do to clarify the law relating to alien enemies is that I'm going to highlight some of the important points mentioned in this case. The first point which was made in this case with regard to alien enemies is that the expression, that is the alien enemy, is not defined in the code, and that is true. So that's why this fundamental confusion which we are having. So when we read the section in the other class, it was almost clear the section is broadly placed. It does not really define who an alien enemy is. How do we determine whether a particular person can be considered as alien enemy or not? Now, the judgment of the Delhi High Court goes one step ahead and says that although the expression alien enemy is not defined in CPC, but the explanation to section 83, something which we just read minutes back, it suggests that the subject of a country which is at war with India would be an alien enemy within the meaning of section 83. Now here there is a question. We are trying to find answer to this question as to who is an alien enemy, and going by the statement of Delhi High Court, at least for me, situation gets further complicated, because in defining, or at least in trying to exemplifying alien enemy, it refers to another concept and says that subject of a country which is at war with India would be an alien enemy. Now, who is the subject? Who is the subject of a country? And if India is at war with that country, then India would be considered as an India would consider the subjects from that particular country as alien enemy. Now, quote further. So that's the first point which has been made. The second point which has been made by the court was that section 83 only bars the right to sue in an Indian court if the person concerned is a resident of a country which is at war with India. Now, this is a very important aspect. Now, look at all these points one by one. The first point which court is making is that the term alien enemy is not defined in the CPC. First. The second point which the court is making is that if you read the main provision and the explanation, the main provision, that is section 83, and the attached explanation, one can say that the subject of a country which is at war with India is an alien enemy. So the term which is used is subject. Now we need to understand who is the subject. The third point which court seems to be making is that section 83 bars the right to sue in an Indian court if the person concerned is a resident. So it appears as if court is actually using these two terms, subject and resident, as synonymous terms. And we will get further clarification when we will move ahead. So, to simplify what the court said in relation to the third point, that if the person concerned is a resident of a country which is at war with India, then that particular person can be considered as alien enemy. The expression citizenship, nationality, domicile has not been invoked as of now. This is something which you must pay special attention on. Court use the term resident and not citizenship or nationality to determine, or at least to exemplify, who can be an alien enemy. Court stops here, and then it goes on to make another point, and that would be the fourth point for me in terms of how court tried to deal with alien enemy. Court said that when section 83 uses this expression called to sue in section 83, then this expression in section 83 called to sue has not been used in broad sense. What do we mean by this term, that this expression has not been used in broad sense? What we mean by this term is that to sue only means to institute or commence a proceeding. Now there's an implication for this. There's a profound implication for this. And the implication for this is, or can be explained as, just imagine that on 1st January 2020, I was not an alien enemy and I initiated a suit, right? But in September 2020, because I am a resident of a particular country, my country is at war with India and I am declared as an alien enemy, that will not affect the suit which I have already instituted when I was not alien enemy. This is the point which court seems to be implying. This is the point which court seems to be making. The court said that the point of time when the suit is instituted and not to any subsequent stage in the suit is relevant for section 83. The point which I just made. Maybe to explain this point again, as I said, when the suit was being instituted, whether you were an alien enemy or alien friend, that would determine whether that suit should be allowed or not. If when the suit was being instituted, you were not an alien enemy, then that suit is a valid suit. And subsequently, mere fact that you become alien enemy, court has actually held in this case that will not bar the plaintiff from participating in the proceedings. This is the point which court seems to be making. And therefore, court concludes that if the suit has been validly instituted, no subsequent event could affect the right of the plaintiff, the person who has filed the suit. So these are the 5 important points which emerges out of this case. At least I hope we are moving in right direction to understand how are we actually going to identify who an alien enemy could be. Any questions with regard to what court said? I mean, there could hardly be, but any comments on it? Any comments on what court has actually said before we move on to, say, a second case where court has tried to reflect on this idea of alien enemy? Okay, it's there in the chat box. Okay, let me paste again. You can't see the chats? I just want to make sure. Can you see the chat? I pasted it at 1:45. No, yes. Can you hear me?
Yes, sir. Yes, sir. Maybe not in between.
Yes, sir. I just changed my account. I joined it from the laptop, so maybe that was not visible then.
Oh, that's perfectly fine. So generally you lose the chats, right, when you leave?
Yes, yes.
Okay. So this is it. So I hope these 4-5 points are clear, right?
Yeah.
Okay, right. Then we move on to the next case with regard to alien enemy. And these are not private international law dispute, but these matters or these cases are really helpful in understanding who can be alien enemy for the purposes of Section 83 of CPC, something which we are trying to understand. Now, the facts of this case is very interesting. The facts of this case are as follows. The second case, the name of this case is Prem Pratap Singh versus Jagat Pratap Kumar. Now, this is the name of the case. This was decided by Allahabad High Court in 1943. Now, in this case, what happened was that there was a German girl who came to India. And when the German girl came to India, she was working in a hotel, and she was being paid somewhere around 1,000 rupees for her work in the hotel. Now, apparently, she met an Indian boy, and they fell in love with each other. They got married in Mussoorie, and they started living together, of course, once they got married. But subsequently, of course, the wife, this German girl, she got converted into she got converted into Sikh religion, it seems, and she also started saying that maybe she should go and meet her mother and father. Now, husband insisted that you can bring your mother and father back to India. Now, she left India somewhere around in 1937, and she left India in 1937, went to Germany. I think she got her mother and father back to India, and when she came back to India, and this is something which is listed in the case, she realized that her husband's attitude seems to have changed. Now, the husband was not living with her, and also he was not providing her maintenance cost. She was living in a separate residence. In Dehradun, it looks like. And this Jagat Pratap Kumar, that's the name of the women in this particular case law. Now, there were many arguments in this case. The most fundamental issue in this case was that whether maintenance should be provided to the women, and if at all maintenance should be provided to the women, what should be the amount of maintenance. But strangely, there was one argument which was made in this case in between. In very brief, this argument was put forth by one of the lawyers. And this argument was that since Britain is at war with Germany, and we are talking about the Second World War, therefore this women should be considered as alien enemy. Of course, court rejected this argument, but in so doing, court also tried to explain what do we mean by alien enemy and how do we determine alien enemy. And we are just going to read that part of the judgment. Very briefly, court has touched on the alien enemy part of it. The first thing which court said is that we need to define who an alien enemy is. In order for this German women to be categorized or not categorized as alien enemy, we need to understand that what is an alien enemy or who is an alien enemy in the first place. Now, court referred to Halsbury laws of England to get or at least retrieve the definition of alien enemy. And in this regard, the court said that an alien enemy is one whose sovereign or state is at war with the sovereign of England, or one who is voluntarily resident or who carries on business in an enemy's country, even though a natural born British subject or a naturalized British subject. This is very, very important. I think this one simple sentence, which is directly borrowed from Halsbury laws of England, and also being part of the common law system is usually accepted in India, and at least as going by the court's judgment, it looks like that the position in India seems to be the same. What it actually tries to say is that alien enemies are those people or those persons whose state is at war with, say, England, and in our case that would be India. And since at that point of time India was a British colony, and therefore the statement held importance. But that is not all. It goes one step ahead, and it says that anyone who voluntarily resides in the country which is at war with India or carries on business in enemy's country will also be alien enemy. Now, this is something which you will find very, very interesting. Just imagine that I am an Indian citizen and I decide to voluntarily shift to another country for business purposes. And I do business in say XYZ country, and that XYZ country is at war with India. Although I am an Indian citizen, but because I am resident there or I am doing business in that particular country, that would make me an alien enemy. So this is the contribution of this particular case. Are you getting it? This is a very interesting point. At least I found this point to be very interesting. That even though and therefore the last part of this sentence is very, very important, that even though a natural born British subject by every legal standard or naturalized British subject You might be a citizen of Britain, you might be born in Britain. Similarly, I might be a citizen of India, I might be born in India, but the moment I voluntarily become resident or carry on business in an enemy's country, I can still be considered as an alien enemy. Court makes another very small point here. Court says that, look at section 83 of Civil Procedure Code. It says that section 83 lays down that alien enemies which are residing in British India, as it used to be before 1947, without the permission of the Governor General, and in the present case, in the present section, it's central government, or residing in a foreign country, shall not sue in the courts of British India. And therefore, court said that it is a settled law that an alien enemy is entitled to defend if any proceedings are instituted against him. So in the last case, what we saw was that date of institution of proceeding is important. It does not matter whether subsequently you turned out to be an alien enemy. Whether on the date of the institution of proceeding you were alien enemy or not is what is the crux of the matter. In this case, one of the contributions or one of the significant contribution which the court is making is that if a case has been filed against an alien enemy, that alien enemy is entitled to defend himself or herself in any proceedings which are, of course, instituted against him. The other significant contribution this case seems to be emphasizing on, or seems to be making, is that voluntary residence could be a criteria of deciding alien enemy. So look at the terms which we have now. We have subjects, we have residents, twice. Now we go to perhaps the most important case, the third one. The third case, which is Sitalakshmi Achi and others versus V.T. Virappa Chettiar. This is a case decided by Madras High Court in 1955.
So one is residents, the other is subjects. Subjects is not clear here, sir. It means nationals, citizens, or domicile.
Yeah, that is precisely what I said, Manu, that in the first case, when they are using the word subject, they are not defining what they really mean by subject. But if you remember, I mean, at least if others can remember, I said that they seem to be using these two terms, subject and subject and resident, at least for the purposes of defining alien enemies. So the court in the first judgment seems to be implying that in order to decide whether a subject is an alien enemy or not, we need to look at the criteria of residence. Are you getting it?
Yes, sir. Yes, sir.
Yeah. Is it clear now? All of you. Any doubts? Yeah. I'm sorry, I've not been able to ask any doubts, any questions. Any question? Any doubt as of now? No, yes. There could be just two answers. Can you hear me in the first place? Let's go to much more fundamental question. All right. Now, maybe this case, thank you, Shubham. Now, maybe this case would clarify the situation in a much more better way. And that is the last case which I studied for the purposes of this class, and that is Sitalakshmi Achi and others versus V.T. Virappa Chettiar. Again, a case which needs to be located during colonial times, and more than colonial times, a case which needs to be located in relation to Second World War. So this case involves some kind of business transaction between a person who is based in Myanmar, and for a very brief period of time in 1941-42, Myanmar was occupied by Japan. Now the question was that can the person who is based in Myanmar be considered as alien enemy for the purposes of the law. Now we are going to talk about, now this entire case traces the history of alien enemy. Extensively quotes public international law scholars, domestic law scholars, including your Oppenheim, Ulla Maki, all of them have been quoted in this particular case to understand what is the idea of alien enemy. Now, this case starts with a very general point. This case says that when it comes to alien enemies, there are two fundamental principles of English common law. Now, what are these two fundamental principles of English common law? The first principle of English common law when it comes to alien enemy is that enemy subject is denied access to English courts. That's the first part. So the moment you are an enemy subject, Manu, I hope you are able to recognize that the word which is being used here is enemy subject.
Yes, sir. Yes, sir.
But we need to further develop on it what enemy subject would ultimately turn out to be alien enemy. So we need to have a more precise meaning of identifying who can be considered as alien enemies. I hope you're understanding that. They are using a broader category now, and then we will subsequently move to a much more specific way of determining alien enemies. I hope it is clear to everyone. The second fundamental principle of English common law, which they are talking about, is that the British subjects are prohibited from trading with the enemy subject up till the time war is happening between the two states. Now, these are the two fundamental principles of English common law, and these two fundamental principles, to a large extent, and at least the first one, we are certain about the first one. That first one is codified under Section 83 of Code of Civil Procedure. With regard to the second one, of course, if you read the judgment, you'll find that there is a discussion whether we should have it or not have it, whether it should be allowed or not, in the sense that whether such a law is also allowed in India. And court says that to a large extent it is allowed in India because there is no other law which prohibits the application of this common law principle in India. So by justice and good conscience, this law should be applied in India. But at least with regard to the first principle, we are certain the first principle is embedded in section 83, that enemy subject is denied access to English courts. Now, the second part of this question could be, who is an enemy? So court asked this question again in this case, that who is an enemy, or alternatively, this question can be put in a different form, is that what determines the enemy character of a person? When can a person be considered as an alien enemy? Now, court said that an alien subject is a person in a situation that if there is a war, a person can be considered as an alien subject when he is in some way connected with the enemy territory or enemy occupied territory. Now, this is a very, very important point. It says that when in some way a person is connected with the enemy territory or enemy occupied territory. Again, it is a very vague way of identifying alien enemy. Some way connected. What is this some way? How do we interpret this term, some way connected to the enemy territory or enemy occupied territory? And therefore, court acknowledges this ambiguity. Court says that yes, it looks like that it is difficult to conclusively argue that whether one instance amounts to some way of connection or not, or no connection. So the court says that if you look at the common law, the test of enemy character is not nationality. Here comes the most absolute statement from the court. We are looking at the third case now, and this is the most precise statement which any one of the courts have met till now. That when we are talking about determination of enemy character, we are not talking about nationality. So it will not matter whether I am an Indian national or not. But what would matter is residence, or even if I am living in enemy territory for whatever purpose it may be. So the criteria for deciding enemy alien cannot be nationality. This is what the court seems to be saying here. But it can be living in enemy territory for whatever purposes it may be. This is point number one. Please remember this point. Point number two, something which court identifies, is that if a person, whether a neutral or a British subject. So for example, consider India. and I'm an Indian citizen. Now, whether I am an Indian subject by nationality, now if I live in enemy territory, even for the purposes of business, I will be treated as an enemy subject. This is what court seems to be saying. So the connection which this judgment has identified, that there should be some connection with the enemy territory or enemy occupied territory. That connection does not imply connection of nationality, but connection based on residence. This is what court is saying. Therefore, what applies to enemy territory applies equally to enemy occupied territory. Fine, there is a country. Now, that country has been occupied by another country which is at war with India. Then, this test which we have just developed, resulting from this court's judgment, would apply to that territory as well. Now, moving on.
So that means it will apply to Pakistan occupied Kashmir also.
In the sense that?
In the sense that the person residing in POK would be considered an alien enemy if India is in a state war with Pakistan.
Yeah, only when there is a war. Yeah, so that caveat has to come, that only when there is a state of war between India and Pakistan. And when we say state of war between the two countries, it has to be declared. Yeah, so that's true. Any territory which is under the effective control of the state with which one is having a war, it applies to the entire territory, going by the principle which we just read. Is that fine?
Yes, sir.
Yeah, okay. Yeah, if you can just say or put it in the chat box, it satisfies me. Otherwise, just like talking to a machine, and I generally get apprehensive if you all are able to listen to me. Now, when considering questions, court goes one step ahead, that when considering questions arising with an alien enemy, it is not the nationality of the person, court repeats that point again, but his place of business during war that is important. That's the important point which the court is saying. The test is not citizenship or nationality. Now, to put it in the form of illustration, say an Englishman carrying on business in an enemy's country can be treated as alien enemy for the purposes of this particular provision. Now, court has specifically tried to answer what Manu was describing in the last lecture. When he asked that question, court said that the subject of a state at war with, say, England, or in our case India, but who is carrying on business in a foreign neutral country is not treated as an alien enemy. Are you getting it? So the subject of a state which is at war with, say, India, but is carrying on business in, say, India or in a foreign neutral country, if it's carrying on business in India, that is with the permission of the central government, or in a foreign neutral country, then he will not be treated as an alien enemy. This is from the judgment of the court itself. Court goes one step ahead, and court says that the validity of, and court fundamentally also tries to reflect on the second principle which I identified at the beginning of lecture. So I identified two principles. One is that the status of alien enemy bars you from instituting a proceedings in the court, and second is with regard to the validity of contracts. And therefore, court says that when it comes to validity of contracts, just like identifying alien enemy, it will not depend on your nationality, but your residence or the place where you are actually doing business. Court summarizes this point multiple times with the help of multiple authorities, that a man, any person, may have, say, business relations or business concerns in two countries. But if he acts as a businessman of both, he must be liable to be concerned. He must be liable to be considered as subject of both with regard to the transactions originating respectively in those two countries. So just imagine that I am an Indian citizen. I am doing business in two other countries, and I'm traveling between both these two countries regularly. Now, while India is not at war with the first country, India is at war with the second country. That also opens up the possibility of me being considered as an alien enemy. And that court specifically mentioned that the point that he has no fixed house or no fixed counting house in the enemy's country will not be a decisive factor. Mere fact that he resides there for the purposes of business, or he does business in that particular country, is good enough ground for him to be considered as alien enemy. Therefore, there are two aspects of residing, and that too in relation to the person without reference to his commercial intercourse. So even if I'm not, say, engaged in a business but residing in a particular country, and that too in the second with regard to the place of business, which many a times in informal language is known as commercial domicile, but the court has tried to clarify it at many point of time that the use of the term domicile here should not be confused with how we understand domicile in technical terms, something which we'll study in the next module. So to put it simply, residence seems to be the determining factor of how we identify enemy aliens. Court again tries to put it in simple words. Court says that just imagine that an alien enemy is one whose state is at war with, say, India, or one who is voluntarily residing or who carries on business in an enemy's territory, even though he is a natural born Indian citizen or Indian national, or for example he acquired Indian nationality through some other mechanism provided in Indian citizenship law. The test which has been taken of enemy character in common law is not nationality, to emphasize that point again, but settled residence, or in case of traders, maybe what is termed in informal sense commercial domicile. Domicile in strictly, so please don't get confused when you study domicile subsequently. When they are saying commercial domicile, they are only trying to convey a sentiment. They are not using domicile in a purely technical sense here, that is desire to live in a particular place for an indefinite period of time. That is how very simply we define domicile in a technical sense. They don't mean domicile in a technical sense when they say commercial domicile. The last point, and something which is very important, court said that this criteria is an objective criteria, and it depends on the facts. Now, what do we mean by objective criteria depending on the fact? When we say objective criteria depending on the fact, it means that it does not matter what prejudice that person might have or what passions that person might have. So that person might be very patriotic, or his determination to free his country whenever he can. All these factors does not matter, going by how common law is placed. What this law actually prescribes is that it is an objective test, and this will depend on the facts of the case, whether the link between the country, between the person and the country which is at war with India can be reasonably established, going by the descriptions which I have just given. Now, the fundamental principle of common law under consideration which we are talking about is, say, the procedural incapacity of an alien enemy to sue. Now, Section 83 is precisely about that aspect, that whether an alien can sue, and we are particularly worried about alien enemies. We don't have any doubt that alien friends can sue, but whether alien enemies can sue or not. Now, how this law is placed? Now, Section 83 is broadly seen as a codification of common law when it comes to, say, procedural incapacity of an alien enemy to sue. Now, in fact, if you read the judgment closely, at least at one point of time, somewhere at the bottom, the court has went to the extent of saying that this premise or the common law aspect which we are talking about have been adopted and applied in India even before CPC came into picture, and the earlier code of 1882 came into picture. So this particular principle actually reached India through Britishers, and it was being applied as a matter of judicial exercise, but subsequently codified in 1882, and then finally the CPC in 1908. That is how roughly the position with regard to alien enemies are placed. Of course, if you read the general literature on it, what seems apparent is that there's immense doubt. There is immense doubt how to determine alien enemy and what are the laws governing alien enemy. But with these three judgments, I think we are fairly better placed. We are fairly better placed to say understand the basic rules with regard to alien enemies, their identification, and in what ways we can conceptualize the business relationship involving alien enemy, and in what situations the suits which are filed by alien enemies can be barred or cannot be barred in accordance with Section 83. So these are 4 or 5 elements which we have tried to cover with the help of these case laws. Now, I hope it is relatively better. With this, maybe I will quickly try to cover some of the aspects which I intend to cover today. One is that when foreign state may sue, and something which I've already talked about, that foreign state may sue in any competent court, but the only criteria or the provision is that, and the proviso of Section 84 is that the object of the suit should be to enforce a private right vested in, say, head of the state or any other officer in his public capacity who was presenting it. So that's a very, very simple way of putting it as to when can a foreign state may sue in any court of competent jurisdiction in India. Now, this brings me to another element, and since I'm just trying to cover some of these aspects, which I think must be covered as part of our discussion on jurisdiction, is with now the third aspect which I would like to cover as part of CPC is that suit against foreign rulers, ambassadors, and envoys, whether such suits are allowed in India. Now, Section 86 deals with this specific aspect. Some of you who have studied public international law will realize that there is something called privileges and immunities, and there are specific laws in India as well called Diplomatic Relations Act 1972. Similarly, we have something called United Nations Privileges and Immunity Act of 1947. So all these both these acts also try to reflect on the question of suit against foreign rulers, ambassadors, and envoys. CPC puts it in a very plain way. It says that no foreign state can be sued in any court competent to try a matter unless and until you take permission or consent of the central government, and that too certified in writing by the secretary of that by the secretary to that government, that yes, the foreign state may be sued. The only exception to this rule seems to be that a person may file a suit as a tenant of immovable property, say without any consent from the central government, as has been mentioned in clause 1 of Section 86. And when I say that as a tenant of the immovable property, it seems very obvious that immovable property should be held by, or that property should belong to, the foreign state. Only in such a situation can a person file a suit. In that situation, no consent from the central government is required. Now, if you look at Section 86 subclause 2, it identifies that when central government prescribes or when central government gives consent to file a suit against a foreign state, it has to take into account certain considerations. So it has to take into account the consideration that that the foreign state has instituted a suit in the court against the person desiring to sue it. Similarly, the foreign state itself or another trades within the local limits of the jurisdiction of the court. And similarly, if it relates to possession of immovable property, then it has to satisfy that the property is situated within the local limits, within the local limits of the court. And similarly, it has also to prescribe that the immunity which has been provided under section 86 subclause 1 has been waived in relation to that particular foreign state. Now, if at all there is a judgment, against the property of any foreign state, then that judgment cannot be executed. The decree cannot be executed without the permission or without the consent of the central government. That's another qualifier which is there as part of section 86 subclause 3. All these provisions are based on principle of reciprocity. When I say principle of reciprocity, what I mean is that a very similar provision would also be present in the domestic laws of another country. So this mutual, I would say, arrangement to make sure that suit against foreign rulers or a state as such, or ambassadors or envoys are not filed, or filed only in a particular way, is something which is a product of consensus among states. What I just identified, that generally as a matter of policy, there seems to be a prohibition that a suit against foreign state cannot be filed, and the other attributes of this procedural aspect, that if at all it is to be filed, a permission has to be taken. While giving permission, certain considerations are to be taken into account. All these provisions equally apply to head of the state, say whoever is head of XYZ state, or any ambassador of a foreign state, any high commissioner of a Commonwealth country, and similarly any member or staff of a foreign state, or for example staff of the ambassador or envoy in a foreign state. So this applies to all these categories of people. Something which we have already studied as part of public international law, that what kind of people are eligible to enjoy immunities and privileges. So that extends to all these people. Similarly, these categories of people which I just identified, that is the head of the state or ruler of a foreign country, although that term is not often used now, the term ruler is not often invoked. Now what is said is head of the state, ambassador, high commissioner of Commonwealth countries, or the member of the staff of, say, ambassador, envoy, or high commissioner. They cannot be arrested under this particular code. So that is how roughly it is placed. Now, unless of course, for example, the privileges and immunities are specifically revoked by the state who is sending the ambassador. In such a situation opens up the possibility, but that is governed by broadly United Nations Privileges and Immunities Act 1947 and Diplomatic Relations Vienna Convention Act. And what are the privileges and immunities which are extended to such staff? I think that should be it for today. It's already 2:30. So let me briefly revise what I did today. My fundamental intention today was to go through the issues relating to alien enemies, and the major reason for doing it was that there was a specific question, and therefore it was needed that we clarify the attributes relating to alien enemy. One of the common attributes which seems to be emerging from the case laws which we covered today is that identification of alien enemy is not done in accordance with nationality. It is done in accordance with residence. Similarly, whether that suit should be allowed, is valid or not as per section 83, has to be determined by the fact that whether on the date of filing the suit, the person was an alien enemy or not. If the person was not an alien enemy on the date of filing the suit, then that suit would continue, because section 83 does not, as per in the words of the code, does not use a broad sense of of this phrase to suit. It merely means, when it says to suit, it means that to institute the suits in a particular court. It further says that the moment a suit has been instituted, it would continue irrespective of the changing character of the individual. This seems to be emerging out of the judgment which we have studied, which of course section 83 does not directly talk about. Also, the aspect that if a suit has been filed against alien enemy, then there's no prohibition against that alien enemy to come and defend himself or herself. That seems to be the general idea. Subsequently, we saw that what are the general prohibitions with regard to suits against foreign state, head of the state, ambassadors, envoys, or for example, high commissioners. So these were some of the aspects which we covered today. That central government has to give a specific permission, and if central government fails to give, and if central government is considering that a consent has to be given, it needs to take into account certain considerations which are listed in section 86 subclause 2. That should be it for today. Now let me move to my other class. If there are any questions, you can put it here. You can drop me an email. You can put it on the class Google Classroom. We will take all these questions one by one. And let me tell you, we were able to have such a thorough discussion on alien enemy because there was a question in the first place. And I must thank you all who were interested in this discussion. That often we don't extend our discussion about alien enemies beyond section 83. But the kind of discussion which happened, it really prompted me to go through these case laws and understand how the laws are placed. In fact, I have a suggestion. If some of you are really interested in doing any research and you are looking for a topic, of course there could be many topics, but I briefly had a look on this subject called alien enemies, and in relation to Indian jurisprudence on this subject, there is very few literature. In fact, I'm consciously restraining myself from making that statement that there is no literature, though there's no comprehensive literature on the subject. So if you are trying to put something together in short, in a very brief manner, this could be a good area of research. Maybe not a big article, but a very small one, mostly for your self-understanding. Who is an alien enemy and how courts have actually tried to deal with the idea of alien enemy.
दोस्तों, ब्राज ग्रुप आशा करता है कि आप सभी लोगों को ये लेसन पसंद आया होगा। आप अपना फीडबैक कमेंट बॉक्स में देना न भूलें। थैंक्स फॉर वॉचिंग।